Hello everyone, welcome to SEO Explains. I'm Gauri
And I'm Spandana.
and today's video traces the remarkable evolution of queer persons' right to marry in India.
We begin our court in review with a case from over a decade ago, where the Supreme Court found that criminalization of consensual homosexual intercourse was constitutional. We then map out how the court's jurisprudence evolved to recognize the rights of LGBTQIA persons.
Across 5 cases, we look at how personal liberty, dignity, and expression has evolved for the queer community. Let's dive in. Our story begins with one provision of the Indian Penal Code, Section 377. This provision criminalized unnatural offences. What were these unnatural offences? Carnal intercourse against the order of nature with any man, woman, or animal. The law always viewed consensual intercourse between same-sex persons to come under this scope. In 2009, the Delhi High Court turned this view around. It held that Section 377 cannot be used to punish consensual sex between two adults, as it violates the right to privacy and personal liberty under Article 21 of the Constitution. The High Court held that targeting and classifying homosexual persons goes against the equal protection guarantee outlined in Article 14 of the Constitution. Several organizations and individuals who are unhappy with this judgment of the Delhi High Court took this case to the Supreme Court. They argued against the decriminalization of homosexuality, claiming that the right to privacy should not extend to committing offences. You'll remember that the IPC had categorized these activities as offences. They also expressed concerns about the potential impact on marriage and feared that the decision would influence young people to engage in same-sex activities. In 2013, in Suresh Kumar Kaushal versus Naz Foundation, the Supreme Court reversed the Delhi High Court verdict. It held that only Parliament had the authority to decriminalize homosexuality, not the court. It held that Section 377 didn't target or classify any group of persons, it simply criminalized certain acts. They highlighted the relatively small number of individuals within the queer community who had been prosecuted under 377. Despite the setback, several curative petitions were filed in the Supreme Court asking for this case to be reconsidered. While this was happening, in 2016, 5 individuals from the LGBTQIA community, renowned Bharatanatyam dancer Navteej Singh Johar, restaurateurs Ritu Dalmia and Aisha Kapoor, hotelier Aman Nath, and media person Sunil Mehra filed a fresh writ petition. Their goal was to scrap Section 377 IPC, specifically in cases where it criminalized consensual sex between same-sex individuals. The fruits of this petition would be seen 2 years later in 2018, but let's get to that in a second.
A year after the Suresh Kumar Kaushal versus Naz Foundation in 2014, the Supreme Court legally recognized the third gender or transgender persons in National Legal Services Authority versus Union of India. The Supreme Court acknowledged the rights of persons who do not belong to the binary of male and female to self-identify their gender. The court clarified that gender identity was not limited to biological characteristics. Instead, it was an innate perception of one's identity. The court expanded the interpretation of dignity under Article 21 to include self-expression. It found that self-expression was crucial to lead a life of dignity. Further, the court recognized that the right to equality under Article 14 and freedom of expression under Article 19 were deliberately phrased using gender-neutral language, that is, all persons and not just men and women. They also held that values of privacy, self-identity, autonomy, and personal integrity are fundamental rights guaranteed to members of the trans community. What this case did was explicitly declare that non-binary persons enjoyed fundamental rights vested in our Constitution. This set the background for pushing the envelope of rights from their basic understanding to secure the rights of a dignified life for the queer community. It also set the stage for the next case on our list, where 9 judges of the Supreme Court declared that privacy was a fundamental right.
In 2017, the Supreme Court delivered what is perhaps one of the biggest judgments of our generation, Justice K.S. Puttaswamy versus Union of India. Here, the Supreme Court recognized the right to privacy as a fundamental right. But how does this affect gender identity, sexual orientation, or marriage? Let me read an excerpt from the Puttaswamy judgment that I've got right here. Privacy of the body entitles an individual to the integrity of the physical aspects of personhood. The intersection between one's mental integrity and privacy entitles the individual to freedom of thought and the freedom to believe in what's right and the freedom to self-determination. When these guarantees intersect with gender, they create a private space which protects all those elements which are crucial to gender identity. And the next part is important here. The family, marriage, procreation, and sexual orientation are all integral to the dignity of the individual. So we see here that the court clearly draws a connection between what it means to enjoy a life of dignity and how the right to self-determination of one's gender, sexual orientation, family, marriage, and other such meaningful aspects of life. This judgment laid a strong foundation for the years to come.
We see its first big effect in 2018 when the Supreme Court decriminalized consensual homosexual intercourse. We go back to the cases filed in the aftermath of the Suresh Kumar Kaushal judgment, which now had a new ground to fight on. To quickly recap, in this case, members of the LGBTQIA+ community had challenged Section 377 of the IPC, which criminalized unnatural sex. This included intercourse between persons of the same sex. The 5-judge bench struck down Section 377 to the extent that it applied to the queer community. First, the court identified that discriminating persons based on gender identity or sexual orientation clearly violated Articles 14 and 15 of the Constitution. Second, criminally prosecuting persons for engaging in consensual sexual intercourse based purely on sexual preferences violated one's right to live a life of dignity and the right to personal autonomy and choice. The court also recognized that stifling a person's identity was a violation of the right to freedom of expression.
Now we come to our fifth and final case on our list. Supriya Chakrabarti versus Union of India. Here, two same-sex couples approached the court seeking legal recognition of marriages between persons of the same sex. Specifically, they argued that Section 4C of the Special Marriage Act was unconstitutional. This provision only recognizes marriage between a male and a female. They argued that excluding queer couples from enjoying the right to marry deprives them of marital benefits such as adoption, surrogacy, inheritance, social security benefits, and more. This petition was heard together with a bunch of other cases, all seeking the right to marry for non-heterosexual couples. Broadly, the petitioners argued that depriving queer couples the right to marry violates the right to equality, the right to live a life of dignity, and of self-expression. The union argued that the court was not the appropriate forum to ask for this right. Lawmakers would have to gather to discuss whether the Special Marriage Act would include queer couples. They also argued that ancillary rights such as social security benefits and marital benefits could be granted by tweaking relevant laws. Just these administrative changes could be sufficient. The court need not declare a right to marry. Many advocates on the union side also argued that legally recognizing queer marriages would adversely affect the welfare of children and would break the natural form of family. This year, a 5-judge constitution bench heard this case for 10 days and completed hearings. We expect the judgment to be released soon.
The petitioners in Supriya versus Union of India appear to have a strong series of precedents to support their claim. But will this be enough to change a law that strikes at the heart of how families work in India?
Thank you for watching this episode of SEO Explains. Like, share, and subscribe to our YouTube channel for more on the Supreme Court of India.
As always, visit seobserver.in for more.